We have now, Mr Chair.
Thank you, Mr Chairman. And I want in this part of the bill and in this contribution to focus on National Party members and ask them to examine their conscience. Stephen Joyce, the promoter of the John Key Casino extension, giggles. He giggles at the thought of a National Party member having a conscience. And I think, sir, that is disgraceful. He's not an experienced parliamentarian, but most people, even if they've just read the history of the country, know that the National Party has a tradition of allowing its members to have a conscience vote. And members opposite say we went to the election on the issue. Well, I think to a certain extent some of them did. Some of them did go to the election, and John Key certainly went to the election on a convention centre, but I remind them of the people of integrity of the National Party of the past who, notwithstanding going to the election on an issue, had the courage to stand up and say no. I refer the members to Ralph Hannon. Ralph Hannon was the former Mayor of Invercargill, from memory. He was a Minister of Justice, the Attorney General in the Holyoake National Party. He went to his party, led by Holyoake, went to the election in 1960 and promised to undo the suspension of capital punishment that had been instituted by the previous Labor government. Ralph Hannon said, notwithstanding the fact it is my role to introduce this bill, because that's my obligation as a minister, as a part of the Holyoake government, my conscience will not let me vote for it. And what that man did was that he introduced a bill and he voted against it. And I say to Jonathan Young, where is your conscience? Mr Young knows absolutely that this bill, and in particular the interventions in Clause 4, Part 2, the subclause 2, is an area where the agreement, which is not even specified in the bill. So what we have in here is a bill which specifies an agreement and says that the interpretation should be based on the agreement. But is the agreement available in the legislation? No, it's not. No, it is not. They haven't even bothered, because they're trying to keep it all secret. They're trying to say that this Parliament, in Clause 4, Subclause 2, should interpret the legislation, interpret the agreement as overriding the legislation, notwithstanding the fact that they are not prepared to put the entire agreement into the schedule of the bill. They've cherry-picked it. They've picked up a clause here and a clause there that they want to have highlighted, and they've made them in the schedule of the bill. But the important part of the agreement, signed by Stephen Joyce, initiated over drinks by the Prime Minister, is not in the bill. And I say to Jonathan Young, shame on you, because shame on... So since when, in the history of the Parliament of New Zealand, have you been told that you go to a website, according to Jonathan Young, for something which overrides the letter of the legislation? For goodness sake, what sort of Mickey Mouse Parliament are we talking about? Chris Archinvold, his head's hanging in shame at the interjection. I just say to Jonathan Young, how many people is he prepared to have die as a result of this legislation? 1, 10, 15. How many extra people are going to be murdered as a result of not paying their debts? How many more bodies in suitcases are going to be found in the Auckland harbour of people who couldn't pay their debts.
The question is that the question be now put. Those of that opinion will say aye. To the contrary, no. The ayes have it. A party vote? No. Personal? No. We're not accepting personal votes on part 1. Part 2, there'll be... No. Point of order, the Honourable Trevor Mallard.
Mr Speaker, I would like to refer you to McGee. This is somewhat unanticipated, so I'll have to go to the particular part. McGee makes it absolutely clear that gambling issues are areas where there is a traditional conscience vote. Now, Mr Speaker, I do accept that it is the right of the chair to decide when a personal vote occurs, but I ask you to examine the precedent that you are setting for having something which is a gambling issue. And I want to point out, for example, in this bill, looking at the purpose clause of the bill, looking at the interpretation clause, especially 4.2, and clause 5 of the bill, which binds the Crown. Every single one of those involves extra gaming.
I thank the member for his points that he's brought up. There is an agreement from the Business Committee, and whether the member is aware of it, that there will be personal votes allowed on Part 2. And here is the letter that's gone to all parties, and it's dated the 5th of November. There is an agreement that says that Part 1 will be done by party vote, and that Part 2 will be done by way of a personal vote on a conscience matter. And so that's the decision of the Speaker. That's the decision that I have ruled on, and we will now have a party vote that's been called for. The Honourable Trevor Mallard, is this a new point of order? Because I've actually ruled on the speech.
I've heard your ruling, sir. Are you ruling that the Business Committee agreement can strip from a member their right to have a personal vote? Can you show me the standing order which allows that?
I'm referring to the Standing Order 139, where a Speaker considers that the subject of vote is to be treated as a conscience issue, the Speaker will permit a personal vote to be held instead of a party vote. Now, Part 1, the issues about conscience matters are in Part 2. They're not in Part 1. And so the points that have been made, and I refer the member to the decision of the Business Committee and the Speaker's letter to the parties, which I am upholding. And so on that basis, I have ruled. I'm not going to entertain it further, Mr Mallard, because I have ruled, and I'm ruled what the Speaker has determined. Mr Speaker has determined it is an agreement of all parties on the Business Committee, and it's not for me to actually deviate from that. And at the end of the day, at the end of the day, it is at my discretion. I have ruled that Part 1 is to be done on party vote as per the Speaker's instructions. Part 2 by way of a personal vote on conscience matters. Now, the Honourable Trevor Mallard.
I move that the Speaker be recalled in order to contest the ruling you've just made.
The question is that the Speaker be recalled. All in favour will say aye. Aye. Contrary, no. The Speaker will be recalled.
The House is resumed. Mr. Chairman.
Mr. Speaker, you have been recalled on the basis that I disallowed a closure motion was put. I accepted the closure motion and put it to the House, to the committee. At that stage, the Green Party asked specifically for a personal vote. I denied a personal vote, and subsequently I have used the letter that you have written to the parties as it is your prerogative to do, stating that part one would be, because procedural matters would be on the basis of a party vote, if a party vote was called for, and that part two, because they are conscience matters, would be in fact, if a personal vote was called for, a personal vote would be allowed. So I have quoted the letter from your office, signed by you, sir, on the 5th of November, which states the position quite clearly, and on that basis the ruling that I made was that we would accept a personal vote, we would accept a party vote on part one, but not a personal vote, is the decision and the ruling that I made.
Honourable Trevor Mallard.
I think it's fair to say that Mr. Tish has summarised the situation well. I now have received a copy of the letter which you have sent to the party whips. Mr. Speaker, I do want to point out that nowhere in this letter does it say that part one will be treated as a party vote. What it does is indicate that certain matters will be treated as conscience issues. One of those, in the dot point at the top of page 2, and I'm researching this relatively quickly, is changes to the regulatory regime for gambling and the application of proceeds of gambling. Mr. Speaker, I refer you in part 1 to line 19, 20, 21 and 22, which deal with regulatory concessions and the definition thereof, and brings them into the Act. Sir, it's clear just from a very brief reading of your letter that in fact these amendments, or that amendment at least, comes within the gambit of your letter, and therefore should allow for a personal vote. Mr. Speaker, the next point, the point that I was, so that's number one. I apologise. It wasn't a matter which I was aware of before, or I would have brought it up because I hadn't had I've just read your letter and compared it to the bill. The next point that I want to make, sir, is the indication from the chairman that he had been directed by you. Well, that's actually a quote. The direction of the Speaker was the words used by the chairman of the committee. Of course, sir, that cannot be because you, I'm sure, would give guidance and not direction in these matters, because otherwise the right of the chair to act as he sees and following the debate would be fettered. Sir, the last point, and I do want to say that this we might have been, if you like, one vote premature in calling for a personal vote. You know, there might be a good debate around. You know, I think we'd have a debate around whether the closure motion is a personal vote or not. It might be that there could be an argument as far as the closure motion is concerned to do with the government business and getting it through, that those votes might be a party vote. but Sir, it's probably worth, given the ruling from the chairman that this is part of part one, as opposed to a procedural motion, it might be worth considering it as a package. Sir, the last point that I would make is that if one looks through these definitions, we go to licensing on page 4, about a third of the way down, and we also go to the legislative implementation of the agreement, which is not counted in the schedule. So if one looks at on page 5, clause 4.2, that is the clause which gives effect to the agreement, and therefore is a major operative clause in the extension of gambling and the implementation of those provisions. My submission to you, Mr. Speaker, is that this part includes 3 or 4 provisions which change gambling, that McGee and other learned people who have written on the matter have made very clear in the past that gaming provisions are matters of conscience, and Sir, I'm asking you to rule that your letter stands, and that is guidance but not direction to the chairman, and that it would be appropriate for him to review his mistaken assumptions as to the effect of this part in relation to the letter which you have provided.
Thank you. Tim McIntyre.
Thank you, Mr. Speaker. I just want to indicate that the chairman did not indicate to the committee that he was in any way being directed by you. What he did make very clear for the guidance of the committee was that you had, after discussion in the Business Committee, written to members to indicate that all parties had agreed on the procedure that was to be followed. And there's no doubt in my mind that the chairman was simply upholding the intent of that letter and the agreement that was reached by all the other parties. I also want to indicate, Mr. Speaker, that in this instance we were dealing with a procedural motion, and the suggestion that anything other than a party vote should be taken on a procedural motion is, I would have thought, quite extraordinary.
No, I'll hear from Materia Turo.
Thank you very much, Mr. Speaker. We too have seen the letter. It is our understanding in the Greens that unless we call for a personal vote, no such vote will be held. There has been no express indication from the Chair or from any other official as to which parts of the legislation may or may not be considered appropriate for a personal vote. So we are in no position other than to call for a personal vote at every opportunity so that those personal votes will be held. If there is no indication, then we may well miss the opportunity to hold a personal vote, which we consider is very important, unduly. So without further indication, we have no choice but to continually call for a personal vote in these circumstances.
I'll hear from the Honourable Jerry Brownlee.
Mr. Speaker, firstly, I think that you did a good thing in providing guidance to all parties about how, as the primary presiding officer of this Parliament, you would see this bill being dealt with where there is clearly disagreement.